Great. Well, thank you for joining us and welcome once again. My name is Doug Skilton and I'm a commercial litigation partner in Thompson Stanton Passmore's dispute resolution team, and I sit on our charities and not-for-profit sector group. And I have the pleasure of introducing our two extremely knowledgeable speakers today. First, my colleague Naseema Ansari, who's a senior associate in our will, trust and estates disputes team. And second, Charlotte John, who's a barrister at Gatehouse Chambers and a deputy district judge. I'll tell you a bit about their expertise in a moment, but in this session, Naseema and Charlotte will be speaking for about 20 minutes each on the impact that will challenges and inheritance claims can have on a legacy left to a charity. They'll explore the reputational risks of defending or pursuing claims and some important strategic considerations, as well as some of the ethical issues that are particularly relevant in charity litigation. So my colleague Naseema is a member of the Association of Contentious Trust and Probate Specialists, having completed her diploma with the University of Law, and she has nearly 20 years litigation experience, and she deals with trust and estate claims, including challenges to the validity of wills, Inheritance Act claims, and claims against trustees and executors, as well as disputes relating to the beneficial ownership of property. Naseema is also well versed in advising on various forms of alternative dispute resolution, such as mediation and without prejudice negotiation, which can help to resolve matters out of court. And we're delighted to be joined by Charlotte John, a barrister at Gatehouse Chambers. Charlotte has particular expertise in disputes relating to the administration of estates and trusts, contentious probate, property disputes, as well as court of protection matters. And Charlotte is recommended in both the Legal 500 and the Chambers Legal Directories, and she's regarded as a leading barrister in her field. Charlotte's also accredited with STEP, which is the Society of Trusts and Estates Practitioners, and she's a qualified arbitrator. Somehow, Charlotte also manages to find time to sit as a deputy district judge in the county courts and the financial remedies court, so we're very grateful to her for joining us today. And Naseema and Charlotte have a lot of content to get through, so without further ado, I shall hand over to Naseema.
You're on mute, Naseema.
Thank you very much, Doug. Cara, could I ask you to just skip through the first couple of slides? And we've got our charity sector team here at Thompson Stanton Passmore. You will get the slides later, so please don't feel you have to madly rush to take down notes. You'll get our details as well. And if we could then press on, that's it. Thank you, Cara. So sadly, charities have received and continue to receive a lot of negative press. You may well recall the case of Olive Cook, which received an enormous amount of adverse publicity for charities when she sadly took her own life in 2015. It was found that she had been receiving a vast amount of correspondence from charities for donations. The Sun said, poor Olive, 92, was hounded by other charities, 10 begging letters a day. And we have the Daily Mail too, who said, poppy seller Olive Cook, who killed herself after being hounded by charities, was on 99 organisations' hit lists. The press presented her as having been hounded to death, although her family disputed this, and it later emerged that she had long suffered depression and had other issues that had led her to end her life as she did. Nevertheless, it caused a huge amount of damage to the reputation of the charitable sector, as you may well know, and its fundraising methods, and the case left lingering beliefs that charities can be greedy. The Daily Mail is particularly scathing in its criticism of the charity sector, and for that reason, and not because that's my paper of choice, I've listed here some headlines for you. So we've got revealed royal charity that partnered with Prince Harry's life coaching firm spent 98% of £796,000 cash it raised in 1 year on paying just 10 staff. And then apparently the MPs having a blast at charities. Deplorable conduct. MPs blast charities taking millions from the taxpayer to fund their migrant battle as a regulator warns them to stay out of politics. And then a stab at Oxfam. Once proud charities lost moral compass, and then again the next day. Oxfam is a toxic charity that has shifted so far from its original aims to be almost unrecognisable. Next slide, please, Cara. So given all this negativity, is this a reflection of the public's perception, and has this had an impact on legacy giving? Well, it actually is not looking too bad for legacy giving. I've had a look at the SME and Ford report, which represents legacy income received by charities registered with the Charity Commission for England and Wales. Each organisation has a total income exceeding £500,000. Now, 2022 shows to have been a really positive year for charities that receive legacy income. Revenue from legacies is at its highest level it has ever been. Total legacy income has increased to around £3.7 billion. Now, that's a 13% increase from 2021. SME and Ford say that they are seeing record highs for the number of charitable estates and the value of those estates. There's 37,053 charitable estates that have been identified in 2022, and this is on par with the previous year. I was at a seminar recently, and these numbers were being discussed, and a question that arose was, what will be the impact of the cost of living crisis on charitable giving? Well, it may be that people will have slightly less to leave, or that they may choose to benefit their children more because they may be going through financial hardship. But we really will just have to wait and see. Could we have the next slide, please, Cara? So the charity's been left a gift in a will, and that's great. But that does not unfortunately mean that the gift is risk-free and that the charity is guaranteed to get that amount specified in the will. If a will excludes or makes limited provision for close family members, there is always a possibility of claims being issued or threatened post-death. I'm firstly going to look at will challenge claims, which is basically claims challenging the validity of a will or codicil. And there are various grounds under which a will can be challenged. So we've got them listed here, which is the ones that we deal with all types of will challenge claims, and we do get them under all different headings. What we've got here is lack of proper formalities, and we're talking about that the will was signed properly, that it was witnessed properly, and there are sometimes issues with this with homemade wills, or what I have seen is wills that have been made in the lockdown period and could not be executed properly. We have lack of testamentary capacity, and the test for lack of testamentary capacity is set out in the 1870 case of Banks and Goodfellow, which, even though it's an old case, is actually still good law. And so this is the test that is still applied today. Now, often something that goes hand in hand with lack of capacity is lack of knowledge and approval. So if you didn't have the capacity to make your will, then you may not have known exactly what the terms of that will are, and may not have been able to approve it. Fraud or undue influence, we get quite a lot of this. A child who has been present at the will execution meeting or the will instructions meeting, somebody who has put a bit of pressure on mum or dad to change their will, to leave out another sibling. Fraud is particularly difficult to prove, but I've often come across cases where wills are changed in suspicious circumstances, where elderly testators change their will shortly before their death, or when the testator is terminally ill or under medication. I've seen wills being changed when testators have been at the very end of their life, even as close as a month before their death. These things are suspicious circumstances that need to be investigated, and there is often evidence that you can gather and questions that need to be asked. Fraudulent calumny is quite a tricky one, and there are limited cases on this area just because of the nature of the claim. Now, this is an incident where one person has poisoned the mind of the testator, causing that testator to not leave a gift to another. As I said, it can be quite difficult to prove. And then there's subsequent revocation. So if the will has been revoked by the fact that a new will has been made. As I said, if you feel that there are suspicious circumstances around a will being changed, this should be questioned, because what I will discuss later is that this can have consequences on the charity and the legacy that the charity has been left. Next slide, please, Cara. So what's the result of a will being challenged, and what happens if the court determines that actually that will is invalid, that perhaps the testator lacked testamentary capacity, for example? If there is a previous will, then the terms of that previous will apply. And if the charity is not named in that previous will, then unfortunately the charity will lose out. And if there is no previous will, then the rules of intestacy will apply. And the rules of intestacy don't make any provision for charities. So therefore, once again, the charity will lose out. So you might be wondering, well, what can I actually do to actually get some background information on how this will was made or how the will was changed? Well, there are ways to obtain information surrounding the circumstances of the testator making his will from the solicitor that prepared the last will. This is something known as a Lark and Nugas request, which comes from the case of the same name. And this can be helpful to establish whether indeed the testator changed his will of his own free will, or whether there was undue influence exerted on him by another, or even that the testator lacked testamentary capacity. You can look at the notes and you can check who was, for example, in attendance at the will instruction meeting or the will execution meeting. That would give you some information as to whether there was some sort of undue influence. And you can check whether the solicitor obtained any medical evidence. Did he obtain a letter from a GP to satisfy that the testator that he was making a will for had the necessary testamentary capacity to make a will? Next slide, please, Cara. The other type of claim that we see most often in respect of claims against the estate are claims under the Inheritance Provision for Family and Dependents Act 1975. The 1975 Act enables certain individuals to claim a share of a deceased person's estate if they have been left out of a will or not left a reasonable share of the deceased person's estate. This applies both to estates where the testator has left a will or where the testator dies without making a will. So the testator dies intestate. Those who fall within one of the categories listed in this slide, and which is listed in section 1180E of the Act, can make a claim. And this and the list of persons includes the surviving spouse or civil partner of the deceased, a former spouse or civil partner of the deceased who has not remarried, a cohabitee living together in the same household as husband and wife for 2 years immediately prior to the death, a child of the deceased, any person not being a child of the deceased who was treated by the deceased as a child of the family, and a dependent of the deceased. Now, in order to be successful, the applicant needs to show that they have a need for reasonable financial provision for their maintenance. So that's for everyday living. There is a lower threshold for spouses and civil partners than for other categories of persons listed. But I'm not going to go through all of that here today because that's quite detailed and it would take us well over the time limit that we've got. But you've got here a list of the persons that can bring a claim and who really could put the legacy at risk. Next slide, please, Cara. So what does the court take into account in deciding whether provision should be made? Well, Section 3 of the 1975 Act sets out the factors which the courts will take into account. These are listed here, and I'm just going to pick out a couple which I think are quite relevant in terms of the charitable sector and whether the court will determine that the applicant should be awarded a financial provision.
investigation, there may be a question mark over that.
Current and future financial resources and needs of the applicant and the beneficiaries of the estate, any obligations and responsibilities which the deceased had towards the applicant and the beneficiaries, and any other matter which the court may consider relevant, for example, the party's conduct. Charlotte's going to touch on the party's conduct issue in a bit more detail later, because she's going to be talking about claims by estranged adult children. But for my part, the difficulty that the court has is that the court must consider the competing needs of all parties, including a charity beneficiary, before deciding whose need is greater, who the deceased has an obligation to provide for, and who may have had an expectation to benefit from the estate. Now, that's not a straightforward exercise, and each case will be decided on its individual fact after carefully considering a balancing exercise. And it can be very difficult for a charity to pit their needs against those of an individual applicant under the 1975 Act. Perhaps the most obvious reason being that as an impersonal body, a charity will inevitably find it much harder to evidence and quantify a need for provision on behalf of its charitable objects or purposes when faced with the competing need of, say, a wife or a child or other dependent who enjoyed a personal relationship with the deceased and who is suffering daily hardship as a result of their death. That's not to say that the charity has no chance of defending a 1975 Act claim. Charities rely on donations and gifts during a person's lifetime and after their death to survive and to fulfill their objects and purposes, so they very much can show a financial need. So what can the charity do in defence, or what can it do to gather information? Well, it's helpful to show the testator's intention to benefit the charity, and evidence of this may include details of any discussions that the testator may have had with the charity about leaving a gift or a history of giving to the charity concerned. Frustratingly, though, whether you should defend a 1975 Act claim will be different for each case and for each charity. So it's not possible to give a clear answer or a checklist that you can go through to tick off and to say, well, yes, I should defend, or no, I shouldn't defend, or to say who may get what, as it is very much dependent on each case and the facts of that case. Something that I haven't got in this slide, and which I'm going to quickly touch on because I don't think Charlotte's actually covering this today, is limitation periods to bring a claim. So do you have to be worried forever and a day as to whether a claim is going to come, or is there some certainty as to when you might get your legacy? In respect to will challenge claims, there's no limitation period, unfortunately, for a claim under on the basis that the will is invalid. But the longer that this is left, the less evidence that will be available. So I, for example, got a will challenge claim, which is being brought after 20 years. And currently I'm trying to obtain a will file from the solicitors that prepared the will and some medical records. But given the passage of time, it's likely that some of the evidence will have been destroyed. And so my client will be in a difficult position. Now, in terms of 1975 Act claims, this is a little bit better. The deadline to bring a 1975 Act claim is 6 months from the date of the grant of probate being issued. Claims can be brought out of time, but it will require the court's permission. And if claims are brought late, the court will take into account what stage of the administration the estate is at, and whether any distributions have been made to beneficiaries, and whether those beneficiaries have spent that money. So really, the advice for applicants is to bring claims as quickly as possible. Obviously, if you're the charity who's receiving a legacy, the longer this goes on and no action is taken, the better it is, because you've got more certainty that the gift may actually get to you, which is what ultimately we want to happen. Next slide, please. So on this slide, we've got some cases regarding estranged adult children and the difficulties that they can pose to legacies. Charlotte's going to take over now and discuss these claims with you in a bit more detail.
Thank
Charlotte,
you,
if I could
Nasima.
hand over to you.
Thank you, and good morning, everybody. It's very nice to be with you all this morning. I thought I'd just touch on claims by adult children under the Inheritance Act, partly because these are the most common types of claim that we see, in my experience at least, probably alongside claims by surviving spouses. I think that that's probably a reflection of some very high profile litigation that we've had here that has encouraged people to make claims, sometimes which don't have a great deal of merit, to be honest. But adult child claims also tend to be rather more difficult to evaluate than claims by a surviving spouse, because if a spouse hasn't been provided for or they've received inadequate provision, they're usually going to have a much clearer cut case than an adult child, particularly an adult child who's been off in the world and living independently. I'm not going to take a deep dive into the case law, but given that we're here with the theme of reputational risk today, it is just worth orientating ourselves, because the first step in deciding whether or not you're going to run the reputation risks and the cost risks of defending a claim is going to be about assessing the merits of that claim. Now, I thought we'd just explore the theme of estrangement a little bit, because it is very common that there is some sort of falling out that sets the scene for these sorts of claims, because parents who are getting on with their children don't generally tend to disinherit them. So it's unsurprising that estrangement is a recurring theme in the 1975 Act case law, and it's worth just investigating a little bit how this influences the merits of a claim. It might surprise you that an adult child can launch a claim and potentially succeed even where they've had no contact with a parent for perhaps many years, even decades. And I imagine that you may have heard of the case of Isla Mitson. You may well be familiar with the facts. It's a very significant case. It's really our leading case now in this area. It's the first time that the Supreme Court or the House of Lords before it ever looked at claims under the Inheritance Act. And Eilert itself featured a very long period of estrangement between the claimant, Heather Eilert, and her mother, Mrs. Jackson. The background to that in a nutshell was that Heather had left home secretly at the age of 17 to elope with a boyfriend that Mrs. Jackson really disapproved of. She subsequently married him and they went on to have children together, but Heather and her mother never managed to repair their relationship. And so there was a long period of estrangement, lifelong period of estrangement, really, for something like 26 years until Mrs. Jackson died. And estrangement, what we've learned from Eilert and Mitson is that estrangement tends to be relevant in two different ways where you've got a claim by an adult child. Firstly, the reason for the estrangement, the background of the falling out, is something that the court will consider. So in the Supreme Court in Eilert and Mitson, as we can see on the slide here, Lord Hughes noted that it's not enough for a claimant to demonstrate that they're in a position of financial need. That is always an essential prerequisite for a successful claim. You can't succeed if you're well off and you're meeting your own needs. But financial need by itself isn't necessarily enough to be successful. And what's been said by Lord Hughes and in the case law that's followed is that a claimant has to demonstrate something more. Now, that something more has sometimes been a moral claim, and an example of that might be where perhaps a particularly devoted child has cared for a parent who's then failed to make provision for them in some way. Or it might be some sort of other feature. Disability, for example, is often a common theme. Or it might actually be the estrangement itself that provides that additional factor, particularly if the court considers that the deceased was at fault. And that's what the trial judge in Eilert and Mitson concluded. The trial judge thought that, well, there was a degree of blame on both sides, but Mrs. Jackson had behaved in a harsh and unreasonable manner towards her daughter, both in terms of how she treated Heather during her lifetime and also in the failure to make any provision at all for her in her will. So the courts are willing to get into this sort of slightly murky family history and the business of what caused the estrangement and who was at fault. And you can see strands of this sort of exercise in some of the cases that we've mentioned on the slide here. If the deceased was at fault, this might be the factor that supplies that something more and tips the scales in the direction of the claimant. But estrangement is also usually relevant in a second way. So that even if the court thinks that the claimant wasn't to blame for the estrangement, a long period of estrangement will often set a cap on the extent of the provision that the court is willing to consider making for a claimant. And that's really because a long period of estrangement tends to mean that a claimant hasn't expected to receive anything from their parent's estate, whereas somebody who's enjoyed a close relationship with a parent, well, they might have organised their life differently and possibly perhaps in expectation of an inheritance. And so Lord Hughes in Islet and Mitson said that a judge faced with these sorts of circumstances ought to attach importance to the closeness of the relationship in arriving at his or her assessment of what reasonable financial provision requires. And really, it's the post Islet and Mitson case law here that's particularly relevant. So the case of Nahajek and Fowl and the subsequent cases that follow on your slide. And these cases have demonstrated the way that the court has developed this principle. So we can see in Nahajek, that was a successful claim by an adult child for provision from her father's estate. There'd been a falling out and a period of estrangement between the deceased and his daughter. And the daughter had made various attempts to try and rekindle the relationship, and she'd been, in the court's view, unreasonably rejected by the father. So she succeeded in her claim, but she received only a modest award, £30,000, to help support her in her aspiration to train as a veterinary nurse. Wellesley and Wellesley, on the other hand, is a case where the court reached quite a different conclusion about the relevance of estrangement. This was an interesting case because it involved the aristocracy. Lady Tara Wellesley, she had had a lifelong estrangement from her father, partly because she'd rejected his lifestyle, but also because she'd embraced a life of alcohol and drugs and what was described as bohemia. As a result of this, the court concluded that out of an estate of £1.3 million, the legacy that she'd been left of only £20,000 was sufficient provision in the circumstances. It was her conduct alone that had led to a 30-year estrangement from her father, and that factor outweighed all other factors in her favour. Hirashand is a case that took a slightly different approach to the issue of estrangement. Again, this was a daughter claiming against her father's estate, and the claimant had been estranged for a very long period from her family. But the cause of the estrangement was something that the claimant hadn't had control over. It arose as a result of her psychiatric difficulties. And she was successful in her claim, but again, this long period of estrangement influenced the judge's view of what she should receive by way of reasonable financial provision. And the award that was made to her was limited to short-term provision intended to provide some financial support for a period. And if you do that in the right way, you'll have some. Next slide, please. So I'm just going to shift focus now and tease out a few more additional points about charities as defendants, building on the excellent points that Naseem has already made. In Islet and Mitson, the status of the charities as defendants was very much in focus because Mrs. Jackson had left her entire estate to the Blue Cross, the RSPB and the RSPCA. And the Court of Appeal had made 2 points in Islet that were particularly troublesome from the perspective of charity legacies. The first was that the Court of Appeal had said, well, Heather might not have expected any benefit, but that's not really relevant because the charities didn't expect any benefits either. And then the second point that the Court of Appeal had made was that since the charities had no personal needs to plead, they weren't prejudiced by the award to Heather. Now, thankfully, from the perspective of charities, Lord Hughes in the Supreme Court corrected this position. We can see what he had to say about these points up on the slide. And there are some really important points, I think, that he makes here. And we're thinking about reputation and reputational risk. I wonder if actually you might want to think about some of these points in this particular quote. It might be something that you could think about citing in a press release, for example, because Lord Hughes recognised the special status of charities as beneficiaries who may not have personal needs, but who depend on testamentary bequests for their work. And he emphasised that whilst a claimant who's seeking an order has got to justify their claim and has got to prove that they've got unmet financial needs, the chosen beneficiaries of the deceased do not have to justify the legacy that has been made to them. Now, as Nasima picked up on in her part of the presentation, none of the charities in NILAC could actually demonstrate any particular financial need or particular relationship with the deceased, but it is worth noting that a smaller charity might actually be able to demonstrate financial need for provision that should be taken into account from a funding perspective. And if a charity had particularly close connections to the testator, that could also be a relevant factor. But where there isn't that sort of connection and the charity can't demonstrate any particular specific need, Lord Hughes' statement also seems to imply that the purposes of the charity could be relevant. For instance, he makes the point that some charitable purposes may be demonstrably humanitarian. Well, I think that's rather an interesting comment, and it seems to me to imply that it might be relevant to take into account how deserving the cause is, or what the public impact of the charity's work is. And again, you might want to think about that as a point to emphasise if you're having to give public messaging about why you're defending a claim. Now, generally, these are helpful corrective comments from the Supreme Court. It'll be interesting to see how they develop in the subsequent case law. Next slide, please. I want to shift now into looking at some of the practical considerations for charities in defending claims. Helpfully, the Charity Commission has published some guidance for charity trustees, which goes a long way to clarifying the duties that lie on charity trustees when thinking about embarking on litigation or defending litigation. There's a particularly helpful checklist that you might want to review. The overriding point that's made in the guidance is that the decision to take or defend legal proceedings is one that has to be made in the best interest of the charity after considering all of the available options. And there are, as Nasima has already touched on, recurring themes in the press commentary, very negative press commentary often around charities and legacy litigation. Wasting money is one of those themes. Litigating aggressively with the benefit of expensive lawyers is another. And for all that those comments are very unfair and often very unbalanced, they do highlight some of the tensions in decision making that you have to balance here. Litigation can be a high-risk gamble between protecting your assets, which includes legacy income, but also ensuring that your funds are spent towards your charitable aims instead of on lawyers like Nasima and I. And as the Charity Commission guidance emphasises, every case requires really careful cost-benefit analysis. You've got to consider the relative strengths of your case, the likely costs, the surrounding risks of recovering your costs from the other side. Can they actually foot the bill if you win? You've got to next slide, please. That you lose and that you have to pay not only your costs, but the costs of the other side. Now, my experience is that estate litigation, I'm afraid, can be incredibly costly. It is the sums at stake are more significant, perhaps the estimated costs of £100,000 or £200,000 on each side, sometimes more. So for a small charity, unless you've got insurance in place to meet that sort of liability, a global costs order, if you lose of something in the region of £200,000 to £300,000, that could be of a magnitude that could wipe a charity out. And it has to be noted as well that you can only use funds to meet expenses that have been reasonably and properly incurred in administering the charity. So if you lose the litigation, there may be a question mark over that. So that's not only dangerous from a reputational perspective, it's something that could leave a trustee personally exposed to cost liability. I'm going to come back to some suggestions about what can be done to guard against this in a moment. Obviously, the value or potential value of a claim is going to be absolutely central to this analysis in deciding whether or not it's worth running the risks. And really, the key point to make is that taking and considering specialist legal advice at an early stage to make sure that you're off on the right foot and you're fully appraised of what's at stake is going to be really critical. Next slide, please. So let's have a think about some of the sort of strategic and tactical points that you might want to think about. So, of course, the position that you adopt in any litigation is going to be informed by the particular circumstances of that litigation and the advice that you receive. But it might be worth just drawing out a few points to think about. Firstly, it might actually not be necessary for you to be the person that takes an active role in the proceedings. It might be that there's somebody else in the frame that has got a strong interest in defending the claim, perhaps another relative, and it may be that you can actually leave them to run the charge and leave them to be the party that takes the cost risk, but also from a reputational perspective, leave them to be the baddies. Whether that's going to be an advisable strategy will depend on the extent to which you think that they are going to actively and sensibly defend the claim, and also what's at stake from your perspective. And on that particular point, again, where you've got a small legacy, in most cases the game isn't going to be worth the candle, and it's just not going to be cost effective to get involved. Even if you win, you never get all of your costs back in litigation. So it is possible, even if you're successful and you get your share out of the estate, to find yourself ending up out of pocket because there's unmet costs that the other side hasn't covered. And in some cases, it might be actually that if you've only got a small interest in the estate, that the other parties will be willing to agree that that is preserved. There's an incentive from the claimant's perspective, because the more parties there are joining the fight, the more cost risk there is for the claimant. But also sometimes it's the case if the percentage of the estate is that's going to charity is more than 10%, that can lead to a lower inheritance tax bill. So that might be another reason why the beneficiaries or the other parties would be willing to consider this. There's a quirky little procedure in CPR 57.75. I'm not going to dwell on that, but it is worth knowing about. It's not always the case that you've really got to sort of actively set out for battles. Sometimes it can be that you just want to sort of test the surrounding circumstances that have led to the new will being made. And if you do that in the right way, you'll have some costs protection. It might also be worth thinking, and well, indeed is always worth thinking from the outset at an early stage, what sort of compromises might be sensible? What can you live with? A life interest, for example, might be something that you're willing to concede depending on cash flow considerations. If allowing, for example, a claimant to occupy a property that is owned by the estate would meet their needs, with that the capital value of that property coming to you, well, that might be a satisfactory outcome from your perspective. Real property can be a good investment, and it may well mean that a compromise of that sort of description will mean much more money coming to you further down the line. The importance of negotiating early is something that I would emphasise in every case, because the longer things go on for, the more entrenched everybody becomes, and the more costs each side incurs, the harder it is usually to find compromise. And you need to consider, as I've hinted at, whether or not the claimant can actually meet your costs if you win. A more generous offer in the hope of settlement is usually a more sensible use of your funds than paying the lawyers. Next slide, please. So a few additional steps that you can think about to protect your position. I said I'd come back to this. It might be that you have in place insurance cover, or you can purchase insurance that will cover you for the costs of litigation. But if you can't, or that's not sufficient, in particular, there is a really helpful procedure that you can go to the Charity Commission, and you can apply under section 110 of the Charity Commission for advice from the Commission as to whether or not litigation in a particular case would be in accordance with the charity's objectives and the duties of the trustees. And you can also seek an order under section 105 of the Act, again from the Charity Commission, to authorise the use of your charity funds in the litigation. You can read more about this in the guidance note that the Charity Commission has published that I mentioned earlier, CC 38. But in short, the Charity Commission has got to be satisfied that the litigation is in the best interests of the charity. But as long as you've given them the right information, you will have protection in the event that things don't go as you're hoping they're going to go in the litigation. You'll have some protection, at least to the extent of being assured you're hoping they're going to go in the side of the charity's funds. Next slide, please. There's a few additional points to tease out about costs. The idea that costs will always come out of the estate is a myth. There are some limited circumstances, they're up on the slide, where the court might make a different order in probate litigation, but the general rule is that the losing party pays the winning party's costs. There are ways of tipping the balance in your favour and securing a different order. And the main way of doing this is to think about making tactical offers to settle, so they'll be without prejudice, the court won't know about them, but then you can refer back to those offers when it comes to the argument on costs. And the most powerful way of doing that is making what's called a Part 36 offer. These can be made by claimants, but they can also be made by defendants. And it is a procedural code that is very, very detailed. You have to make sure that you comply with it to get the benefits. But what happens if a claimant fails to beat a sensible Part 36 offer that you made, then you will ordinarily be entitled to your costs. They will be assessed. So this is a departure from the rule that the claimant, the winning party, gets their costs. And ordinarily they'll be assessed on what's called the indemnity basis. It's a more generous way of approaching your costs. It's also a good tactical mean of putting some pressure on the other side when you think the claimant and their advisors probably know that the claim is a bit on the sort of chancy side. All right, next slide, please. So the Charity Commission guidance emphasises that trustees should explore all reasonable options open to the charity to resolve the issue, including dispute resolution or agreeing a legal compromise. Settling out of court has a range of benefits. It's much faster than litigation. If it's successful, it's almost invariably going to be cheaper than taking a case to trial. It's private, and that's really helpful for two reasons. Firstly, because we avoid then the Daily Mail having anything to say about this situation, but also it avoids setting any precedent for future cases. And there's the possibility of exploring perhaps more inventive or creative solutions for compromise that might not otherwise be obtained through court proceedings. There are some potential negatives as well. Settlement necessitates compromise necessarily. You might encounter some cases that are just so lacking in merit that you're not minded to compromise very much. And there can be additional costs. So if you go to mediation and it's unsuccessful, you've obviously incurred those costs in addition to the costs that you're going to incur in taking the matter through to trial. One other point to think about is, might you acquire a different sort of a reputation for being a soft target if you settle too much? Well, I think the answer to this really is to make sure that you've got a confidentiality agreement, a clause that provides that nobody can disclose the details of the settlement in any settlement agreement that you reach. Next slide, please. Mediation in particular tends to be the main form of dispute resolution, and the prospects of settling at mediation are very high indeed. Statistically, it's something like 9 out of 10 mediated cases will settle. That reflects my experience from taking many cases to mediation as well. But there are other options in the toolkit. You can negotiate in writing. That's particularly something to think about if the claim or the estate is low value. Mediation, as I've mentioned, that's usually sort of shuttle diplomacy. Everybody attends on the day with their respective legal teams, and then you've got a mediator who facilitates the discussion for you. Arbitration, that's something that I do. That's in essence private judging. So you appoint somebody to act as a private judge out of court, and again, you've got the benefit of privacy with that. Private early neutral evaluation, that's a bit different. You go off to perhaps somebody, a barrister like me maybe, and you ask them to give a sort of neutral, objective appraisal of the case to assist both sides then in thinking about their positions and negotiating. And there's also a procedure called a chancery financial dispute resolution hearing, where you can get that sort of neutral evaluation from a judge as well. That can be very helpful if you've got a weak claim, because an indication from a judge that the judge also thinks the case is weak is often something that will cause a claimant to take stock and hopefully lead to the claim being discontinued or good terms of settlement being reached. The courts are incredibly keen on ADR. That's the other thing to say here. If you unreasonably fail to engage in mediation, that can carry cost penalties. Next slide, please. I don't want to say too much about ex gratia payments, but it's just worth knowing that this option is there. Ex gratia payments arise in circumstances where the person who is raising the issue of whether or not they should get something from the estate has actually got no legal basis either for bringing a claim or defending a claim. So it's the sort of, technicality. Somebody has perhaps attempted to make provision for somebody in their will, and there is some technical reason that can't be cured as to why that has not resulted in the expected benefit. And the basic point here is that there needs to be some sort of moral justification for making an award. And the Charity Commission recognises that that sort of case where somebody has sorry, I think distracted by comment popping up. That sort of scenario where somebody has not received a benefit that the testator had intended them to receive, that is the sort of situation that can provide a moral benefit. We're waiting to see if the Charity Act 2022, whether there is some additional provisions that are going to come in that are going to make this a little bit easier for you to operate. Next slide, please. Because as matters presently stand, you've got to go off to the Charity Commission and get permission for this. Well, why might you want to think about this from a reputational perspective? What are the benefits? Well, partly it may be something that generates goodwill, but chiefly it may be that making an offer of this sort of description, even if the indicated claim or the reason for seeking a payment of this description isn't something that would actually amount to a successful claim, is that you avoid a disgruntled relative from going to the press with a sob story about how some legal loophole, as the Daily Mail likes to describe these things, has made them lose their inheritance, and with the result that a thankless charity has received all that was intended to come to them. So, final slide, please. Just a few concluded remarks from me. In every case, you're going to have to ask yourself, is this dispute worth the risks, both reputational and financial, to your charity? Early legal advice to get things off on the right course is going to be essential to that evaluation to make sure that you've got a clear idea of the merits and the risks of the position. Legacy disputes tend to attract some of the most unsympathetic coverage for charities. I'd encourage you to have a look at the Daily Mail commentary and also have a look at the below the line commentary, because that's really revealing of what the public think about these things. And that's what we're concerned about here, isn't it? The possibility of discouraging people from leaving legacies to charities in the future. Now, obviously, that's an important consideration, but it's not necessarily the most overriding consideration. There are things that you can think about to mitigate things. PR advice, the use of press releases, perhaps emphasising the sort of points that we saw Lord Hughes in the Supreme Court make about the importance of legacies for charitable causes. And as I've mentioned, capitulating to a claim also carries its own risks. The decision to settle is just as much a decision that has to be taken in the best interests of your charity as the decision to fight. But in many cases, unless the merits are very starkly in your favour, the most sensible strategy is probably going to be to try and reach compromise. And the final point that I would make is that litigation can take on a momentum of its own. Once the train has started, it is very difficult to stop the ride if you want to get off. And Eilert & Mitzen is an absolute prime example of this. Probably a very extreme case, I would say, but 10 years of litigation it took to resolve the issues in Eilert & Mitzen. It generated massive publicity. it generated claims, and the charities in that case found themselves locked into fighting on to the Supreme Court to try and reverse an unhelpful precedent that had been set by the Court of Appeal. So a stark warning, but one that's worth heeding.